There is a nondescript office park on the outskirts of Sioux Falls, South Dakota, where nothing on the glass directory mentions the names of the families whose wealth is routed through the suites inside. There's no marble lobby, no brass nameplate announcing a dynasty, just a door, a buzzer, and a compliance schedule that most of the world will never see. If you walked through the doors of Suite 300, you would find a conference room, a few filing cabinets, a compliance officer reviewing fiduciary logs, and an executive director whose primary daily responsibility is to ensure that a corporate board meets precisely twice a year. That board does not manufacture software. It does not sell consumer goods. It does not run retail stores. Its sole legal function is to act as a fiduciary over several $billion in assets belonging to exactly one bloodline. To the public, to tax authorities, and to commercial registries across the globe, that entity is known simply as a private trust company, or PTC. It is arguably the single most powerful, least understood legal instrument ever designed to keep ultra-high net worth fortunes completely sovereign, completely anonymous, and entirely out of the control of commercial banks. Today, we are pulling back the curtain on this exact mechanism. What a private trust company actually is, why old money routinely abandons institutional trustees to build their own, the brutal tax and legal battlegrounds that make jurisdictions like South Dakota and Wyoming the global capitals of dynasty wealth, and the quiet architecture that lets a patriarch control an empire from beyond the grave without ever technically owning a dollar of it. This isn't hidden, it's just never taught. Before we go further, if the mechanics of how old money actually protects itself interest you, this channel exists to map exactly that terrain, the legal architecture, not the aesthetic. Subscribe now, because by the end of this video, you'll understand a structure that most estate attorneys spend an entire career without ever building. Let's start with the problem that creates the need for a private trust company in the first place, because this is where almost every conversation about estate planning goes off the rails. Most people are taught the basic concept of a trust. You, the grantor, transfer assets into a legal wrapper managed by a trustee for the benefit of your heirs, the beneficiaries. It sounds simple enough, but when a family crosses into 8, 9, or 10 figures of net worth, that textbook structure breaks down completely. In a conventional setup, you hire a commercial trust company, usually the wealth management division of a global mega bank, to act as the corporate trustee. On paper, this sounds safe. In reality, it is an operational nightmare for a dynastic family. A commercial bank's trust department is bound by rigid institutional fiduciary rules and terrifying liability exposure. If the family trust holds an operating business, a portfolio of illiquid commercial real estate, or concentrated equity in a high-growth tech company, the bank's compliance committee will immediately panic. Why? Because the bank's default legal obligation is diversification and risk mitigation. This isn't a cultural quirk of banking. It is a doctrine embedded in trust law itself, known as the prudent investor rule. Under this rule, a trustee is legally expected to manage a trust portfolio the way a professional money manager would manage a diversified fund, spreading risk across asset classes, avoiding concentration, and documenting every decision defensively enough to survive a beneficiary lawsuit. A corporate trustee's primary instinct when faced with concentrated, unconventional assets is to sell them off and redeploy the cash into boring liquid index funds and municipal bonds, precisely the opposite of what built the family's fortune in the first place. Even worse, commercial trustees suffer from constant employee turnover. The trust officer who understood your family's unique dynamics in year 1 gets promoted or leaves the bank by year 3, In their place arrives someone new, someone who has never sat at your family's dinner table, never watched your children grow up, never understood why one grandchild's business venture deserves patience and another's does not. Suddenly, critical decisions about distributions to grandchildren, business expansions, or estate litigation are being rubber-stamped by a rotating committee of corporate bureaucrats who have never met the family and who take 6 weeks just to approve an emergency distribution. Add in the fee structure, where commercial trustees routinely charge anywhere from 20 to 100 basis points annually on the total asset value simply to sign paperwork. And a family holding a $500 million estate is bleeding millions of dollars a year in fees for the privilege of losing control over their own assets. Run that fee drag forward across 30 or 40 years of compounding, and the difference is not cosmetic. It is the difference between a fortune that grows across generations and one that quietly erodes under its own management costs. Enter the private trust company. A private trust company is not a wealth management product. It is a privately held corporation or limited liability company formed specifically to serve as the trustee for a single family's collection of trusts. It does not offer services to the public. It does not take outside deposits. It has exactly one client, the family that chartered it. By creating a PTC, the family essentially fires the commercial bank and replaces it with their own dedicated, captive corporate trustee. The family owns the company that acts as the trustee over their own wealth. This single structural pivot solves the two biggest problems in generational estate planning. It restores absolute operational control over family assets, and it permanently insulates the family from the bureaucratic risk and fees of commercial financial institutions. If you've ever dealt with a bank trust department, or watched a family member deal with one, drop a comment below. The stories we hear from viewers about 6-week approval delays and forced asset sales are often more dramatic than anything we could script. To understand why this is so transformative, you have to look at how a PTC is governed. Because the family creates the entity, they design the board of directors and the specialized committees that make up its operational core. A mature private trust company typically divides its authority into 3 distinct committees: the investment committee, the distribution committee, and the amendment committee. Some of the more sophisticated structures add a 4th, an administrative committee, which handles the unglamorous but essential paperwork of tax filings, statutory compliance, and record keeping across every trust the PTC oversees. The investment committee dictates asset allocation, hires and fires outside money managers, and decides whether the family will hold concentrated equity stakes, direct venture investments, or high-risk private equity positions. Because the PTC is purpose-built for that specific family, the investment committee can draft an investment policy statement that explicitly authorizes holding non-diversified assets, completely neutralizing the diversification mandate that forces commercial banks to liquidate family holdings. This document, the investment policy statement, functions almost like a constitution within the Constitution. It spells out, in writing, that the family's operating business is not a risk to be diversified away, but the intended core holding the entire structure was built to protect. The distribution committee handles the deeply personal human side of the trust. They decide when, how, and under what conditions money flows out of the trusts to family members. Is a third-generation heir starting a legitimate business that deserves seed funding? Or are they requesting capital for a lifestyle splurge that violates family principles? In a traditional bank trust, that decision is made by an anonymous stranger reading a checklist. In a PTC, The distribution committee can be staffed by trusted family advisors, longtime mentors, and non-beneficiary family members who actually understand the nuances of the family constitution and the character of the heir at making the request. Many families formalize this even further, requiring distribution requests above a certain threshold to be accompanied by a business plan, a mentorship check-in, or a documented rationale, turning what would otherwise be an emotional negotiation into a structured, almost board-like review process. The Amendment Committee ensures the entire structure adapts to shifting legal landscapes, updating trust instruments across decades as tax codes evolve across jurisdictions. Without this function, a trust drafted in the 1970s could find itself technically incompatible with tax rules passed 50 years later. A mismatch that has historically forced families into expensive court proceedings just to modernize documents that were otherwise sound. Here is the central paradox that makes private trust companies legally fascinating, and the part where amateur estate planners invariably get destroyed: the problem of dominion and control. Under tax law, if you put assets into an irrevocable trust to shield them from estate taxes and creditors, but you retain the legal power to control distributions to yourself or your children, the tax authorities will pierce the structure. They will declare the trust a grantor trust for estate tax purposes, pull the entire multi-million-dollar fortune back into your taxable estate at death, and hit your heirs with a devastating tax bill. So, how does a family establish a private trust company, control the board, and still legally prove to tax authorities that they have given up control of the assets? This is where the genius of old money legal architecture comes into play, and why the structure looks like a set of Chinese nesting dolls. This next part is the mechanism most people never see explained clearly anywhere, including in most professional estate planning literature, which tends to gloss over exactly how the ownership riddle gets solved. Stay with us. The family does not own the PTC directly. If a patriarch personally owned 100% of the voting shares of the private trust company that acts as trustee over his own irrevocable trusts, the tax courts would immediately rule that the separation between grantor and trustee is an illusion. Instead, the shares of the private trust company are typically owned by a separate, dedicated purpose trust or a non-charitable foundation. A purpose trust is a specialized legal vehicle that exists not for the benefit of human beneficiaries, but solely to fulfill a specific legal purpose. In this case, to hold the shares of the PTC and ensure its governance board operates in accordance with the family's governing charter. Purpose trusts trace their legal ancestry back to offshore jurisdictions like the Cayman Islands and Guernsey, which pioneered star trusts and similar non-charitable purpose structures decades before American states adapted the concept domestically. Because the purpose trust has no human beneficiaries, nobody owns the underlying equity of the PTC in a conventional tax sense. The PTC becomes a legal ghost ship, a fully sovereign perpetual corporation with no individual beneficial owner, operating purely to carry out the fiduciary mandate established decades or centuries prior. Next comes the firewall on the board itself. To prevent the tax authorities from claiming the family possesses a retained taxable power, the distribution committee is deliberately structured so that family members who are current or potential beneficiaries are barred from voting on discretionary distributions of income or principal to themselves or their dependents. Those decisions are handled exclusively by independent directors, trusted attorneys, former corporate partners, or independent fiduciary specialists who sit on the board alongside family representatives. Many families also appoint what is known as a trust protector, a separate role, distinct from the trustee itself, empowered to remove and replace trustees, modify administrative provisions, or even redirect the trust to a new jurisdiction entirely if the legal or political climate shifts unfavorably. The trust protector acts almost like a constitutional check within the system, a release valve that keeps the structure adaptable across a time horizon measured in centuries rather than years. The result is legal perfection. The family maintains complete strategic oversight through their seats on the PTC board and the investment committee, dictating how their operating companies are run and how their capital is invested. Meanwhile, the Independent Distribution Committee creates an ironclad legal barrier that satisfies statutory tax requirements, keeping the underlying assets permanently insulated from estate taxes, divorces, and predatory litigation. This brings us to the question of geography, because a private trust company cannot simply be dropped anywhere on a map. The global map of dynastic wealth is shaped by a quiet, aggressive jurisdictional war between states and countries, competing to become the ultimate legal haven for family capital. For decades, international dynasties looked exclusively to offshore jurisdictions, the Cayman Islands, Bermuda, Guernsey, Jersey, and the Isle of Man. These jurisdictions pioneered the early legislation around private trust companies, offering zero corporate taxes, robust asset protection statutes, and absolute confidentiality. Over the past 15 to 20 years, a seismic shift occurred. Global regulatory initiatives, including automated tax information, sharing agreements like the Common Reporting Standard, stripped away much of the traditional privacy advantages of traditional offshore islands. Banks and trust administrators in these jurisdictions became obligated to report account holder information to dozens of partner tax authorities automatically, year after year, quietly dismantling the exact secrecy that had made those islands attractive in the first place. At the exact same time, a handful of American states realized they could build legal and financial infrastructure that would outcompete every offshore haven on Earth, all while remaining onshore, inside a stable G7 legal system, immune to the reputational baggage that now clings to the word offshore. Today, the undisputed capital of global private trust companies is not Zurich, London, or Grand Cayman. It is South Dakota, closely followed by Wyoming, Nevada, and Delaware. These states have systematically rewritten their statutory trust laws to create the most hospitable environment for private trust companies on the planet. Consider what South Dakota and Wyoming did. If you're taking notes, this is the section worth bookmarking. Save this video now, because the next 3 structural mechanisms are the actual legal levers that separate a 100-year fortune from a 1,000-year one. First, they abolished the rule against perpetuities. Under traditional Anglo-American common law, a trust had a hard expiration date, typically lasting roughly 80 to 100 years before the assets were forced out to the final generation of beneficiaries, triggering massive capital gains and estate taxes. States like South Dakota and Wyoming eliminated this rule entirely, allowing families to establish dynasty trusts that can legally exist in perpetuity. A trust structured through a South Dakota PTC can sit in place for 500 or 1,000 years, compounding wealth across dozens of generations without ever once paying an estate tax, a transfer tax, or a generation-skipping transfer tax as the wealth cascades downward. Second, they created directed trust statutes. In a traditional trust jurisdiction, a trustee is legally responsible for everything: investment management, administrative custody, and distributions. Under a modern directed trust statute, the law explicitly allows the trust's functions to be bifurcated. The statute legally shields the administrative trustee from liability for investment decisions made by an independent investment committee. This means a private trust company can hold volatile startup equity, eccentric private art collections, or leveraged commercial real estate without the fear of fiduciary lawsuits that paralyzes traditional banks. It also means families can separate labor. One entity handles the unglamorous administrative custody work, while a completely different specialized committee, sometimes staffed by people with direct operating experience in the family's core industry, handles the high-stakes investment calls. Third, they created specialized, low-friction regulatory pathways for unregulated private trust companies. In most states, if you want to form a trust company, you have to go through the grueling process of obtaining a state banking charter, subjecting the entity to massive capital reserve requirements, routine public bank examinations, and heavy regulatory oversight designed for public retail banks. South Dakota, Wyoming, and Nevada created a distinct statutory classification specifically for single-family private trust companies. Because an unregulated PTC does not solicit business from the public and manages capital exclusively for related family members, these states waive the burdensome commercial bank reserve requirements. A family can establish a fully functional, legally compliant private trust company with a fraction of the capital reserves, zero requirement for a full commercial banking license, and absolute statutory privacy, with state registries explicitly sealing court, proceedings and ownership filings from public inspection. In South Dakota specifically, trust documents themselves can be sealed by the courts indefinitely, meaning that even in the rare event of litigation, the underlying trust terms, asset values, and beneficiary details never become part of the public record the way they would in a standard probate proceeding. This brings us to the operational reality of what it actually costs to build and maintain this machine, because a private trust company is not a retail wealth strategy. It is an industrial-scale infrastructure play. Forming a PTC typically requires an initial outlay of $200,000 to $500,000 in specialized legal, tax, and structural advisory fees just to draft the corporate bylaws, establish the underlying purpose trusts, align the family constitution, and clear state regulatory filings. This figure typically involves coordinating 3 separate categories of advisors simultaneously: trust and estate counsel to draft the governing documents, corporate counsel to charter the entity itself, and tax counsel to model the generation skipping and grantor trust implications before a single document is signed. Once operational, an active private trust company generally incurs annual operating costs ranging from $150,000 to $500,000 or more. These costs cover the mandatory physical nexus within the charter state, such as maintaining local office space and utilizing an authorized representative or corporate director residing in South Dakota or Wyoming, alongside independent director compensation, annual state filing fees, fiduciary liability insurance, and specialized compliance audits. Because of these fixed overhead costs, the economic math behind a private trust company only starts to make rational sense once a family's total assets held in trust cross the threshold of $100 million to $200 million. Below that level, the administrative friction and operational carrying costs of running a private corporate trustee outweigh the economic benefits, making a traditional boutique trust company or an administrative directed trust relationship more practical. Above that threshold, the arithmetic flips dramatically. For a family managing $500 million or $1 billion across dozens of complex operating companies, real estate assets, and direct investments, paying an institutional bank 50 basis points translates to $2.5 million to $5 million every single year in passive fee drag. By spending $300,000 to operate their own private trust company, the family saves millions of dollars annually in institutional fees alone, while gaining complete fiduciary sovereignty, multi-century tax protection, and total insulation from outside corporate bureaucracy. To see how this works in practice, consider two composite historical patterns illustrating the difference between a family that relies on traditional institutional structures and one that masters the mechanics of the private trust company. The first pattern, the fragmented dynasty. A first-generation founder builds a formidable manufacturing and real estate empire worth $400 million. Upon his death, his estate plan distributes assets across standard irrevocable trusts managed by the trust division of a major commercial bank. Within 10 years, the cracks begin to show. The patriarch's 3 children have completely different visions for the operating business. The commercial bank trustee, terrified of minority shareholder lawsuits and fiduciary liability, exercises its statutory authority to force a sale of the underlying operating business during a market downturn to achieve an easily defensible, diversified portfolio of public securities. The sale triggers hundreds of millions in taxable events, destroys the core cash flow engine of the family fortune, and leaves the second generation fighting a protracted public probate lawsuit over distribution approvals and trustee fees. By the third generation, the remaining capital has been heavily taxed at each generational transfer, fragmented among 12 cousins with zero shared vision, and depleted by continuous institutional management fees. The fortune effectively dissolves, not through a single catastrophic decision, but through a decade of small, defensible, bureaucratically justified ones, each individually reasonable, collectively fatal. The second pattern, the integrated dynasty. Now consider the integrated dynasty. A founder with an identical $400 million fortune establishes a South Dakota private trust company owned by a perpetual purpose trust years before any liquidity event occurs. The PTC's charter embeds the family's long-term governance philosophy directly into its bylaws. The board of the PTC includes the family's trusted senior legal advisor, an independent corporate finance specialist, and rotating seats for rising second-generation family members who have completed structured financial governance education. When the founder passes away, not a single asset changes legal ownership. There is no probate court proceeding. There are no public filings disclosing the size or distribution of the estate. The private trust company continues seamlessly in its role as trustee across all family dynasty trusts. The investment committee maintains the family's controlling stake in the operating businesses, utilizing the cash flows thrown off by those enterprises to fund new direct investments and private credit opportunities. The Independent Distribution Committee reviews educational and entrepreneurial capital requests from the third generation based on objective metrics outlined in the family charter, eliminating sibling favoritism and protecting the family from internal litigation. Because the underlying trusts were formed under perpetual dynasty statutes, the entire capital base compounds across decades without ever being subjected to federal estate tax or generation-skipping transfer tax events. 200 years later, the operating companies have expanded, the underlying capital has grown exponentially, and the institution remains completely sovereign, operating under the exact same private charter designed 2 centuries earlier. That is what separates wealth that lasts 3 generations from wealth that becomes an enduring economic empire. It is not superior stock picking. It is not luck in the market. It is the deliberate, calculated construction of private institutional machinery designed to control capital without owning it, eliminate external friction, and preserve family sovereignty across centuries. This is precisely why families with real generational intent structure their assets years before any inheritance event, not after. If you want to understand the next layer of this architecture, our video on family constitutions and governance frameworks breaks down how these boards actually resolve conflict once money starts changing hands between generations. Subscribe, and we'll keep pulling back these curtains one mechanism at a time. This isn't hidden, it's just never taught.